Welcome to today's session on copyright law. Copyright law can be a complex and expensive area to navigate, especially in today's right-click, save and share digital world. The rise of smartphones and mobile tablets, along with growing social media networks, give consumers and businesses the freedom to capture, share and source images at the touch of a button. Therefore, it is so important to understand some key copyright considerations and how these might apply when consumers and businesses want to use content. The purpose of this seminar is to create awareness about copyright, to help consumers and businesses avoid potential issues and pitfalls before they may arise, so that we can all stay on the right side of copyright. The ReadyTalk webinar tools allow participants to type questions in the text box. Given the large number of registered participants, I will address the questions at the end of the webinar. But please feel free to add questions or comments into the questions panel at any time. If time permits, I will do my best to get through all the questions. However, if I do not get to your question, you can reach out to Getty Images by the email alias that appears in the collateral that will be available following this session. Rather than spending our time dissecting the various legislative frameworks that exist around copyright, we will focus on the practical application of copyright by discussing examples and hopefully providing you with some helpful tips that you can take away from this session. In saying that, we will very briefly go over some copyright essentials, just to make sure that we're all on the same page in terms of what copyright provisions might apply when businesses and consumers want to use content. This session will also provide tips for using works that are subject to copyright, and we will discuss some additional content considerations as other intellectual property rights may exist within works. Finally, I will consolidate the key takeaway messages from this webinar in a checklist. What actually is copyright? Copyright is a set of exclusive personal property rights given to owners in relation to their creations. In most countries in Asia Pacific, there is no system of registration, so copyright is automatically applied upon creation of the work. For example, as soon as a photographer points, shoots, and captures a photograph, that image is automatically subject to copyright. The exclusive rights of the copyright owner allows that creator to reproduce, publish, distribute, display, perform, communicate, and adapt their original work. If anyone else wants to do any of these actions that are exclusively reserved for that copyright owner, permission is needed from that copyright owner. To obtain permission, copyright can be licensed or assigned to another party, as the copyright owner has the right to control the commercial exploitation of their work. The term or duration of the copyright varies depending on the region in which the work was created, according to local copyright laws, and can also often depend on the type of creative work. Very generally speaking, copyright can last anywhere from 25 to 70 years after the passing of the creator. I always put this on a separate slide in red and in bold, as this is most likely one of the most important things that I will say in this session. If anyone wants to use a work that is subject to copyright, or do any of the actions that are exclusively reserved to that copyright owner, you must have permission from the creator, typically in the form of a license. There are very few exceptions to this rule. However, those exceptions are very narrow and limited in their application. For example, a work can be reproduced without permission in the course of legal advice. It is important to keep in mind that these exceptions certainly would not apply to any advertorial or promotional campaigns or marketing collateral or even personal use on a blog. There are a number of works that are protected by copyright. These include literary works, such as letters, emails, journal articles, novels, poems, song lyrics, and source codes for computer programs, musical works and sound recordings, dramatic works such as scripts for films and drama, artistic works such as paintings, drawings, diagrams, maps, engravings, etchings, sculptures, architectural works, and photographs, which is where my expertise lies. So you'll notice that there is an emphasis on visual content in this session, and this session does not focus on other artistic works. Copyright is also afforded to motion pictures and films, and communication works, including radio and TV broadcasts and internet transmissions separate from the film, music, and other materials which they might contain, and, of course, performances. If anyone exercising the exclusive rights of the creator that we touched on before, such as making copies, distributing, displaying, or adapting, without proper permissions in place, will be considered a copyright infringement. If you don't ask permission or have a valid license in place to use an image, or even just part of an image, for example, if this image on the slide was cropped so that the man holding the camera is all that appears without the background, then this would be a copyright infringement. In the digital world that we live in, it is very easy to right-click and save an image. So it's very important to keep in mind that if we want to reproduce an image that we plan to save, we will need prior permission from the copyright owner. A copyright infringement can also occur if content is used beyond the scope of a license. For example, if you have secured a license to use an image for 1 year on your company's website, but 2 years later, the image still appears on that website, or you decide to use the image on platforms other than the website, this will be unauthorized and once again a copyright infringement. A helpful tip is to keep in mind that some licenses expire, so keep track of any expiration dates and be ready to either remove or relicense that piece of content. Another example of copyright infringement is adapting a work without the relevant permission. The rights you are granted will most often be detailed in your license terms and conditions, so be sure to read those terms and conditions to understand the grant of rights that has been afforded to you. For example, editorial images, such as news and entertainment images, generally should not be manipulated, as this will ensure that the editorial integrity or story that is being told by that picture is upheld. So why do we really need to worry about copyright? For creators, receiving a royalty payment for use of their works is the way they make their money, and it is their livelihood. So for most creators, they are very prudent about protecting their rights and ensuring that they are properly remunerated. So it is possible and quite likely that creators will keep abreast of any uses of their content and question if there is a valid license or permission in place for certain uses. If it turns out that you have infringed someone's copyright, they or their representatives are able to bring legal action and sue for damages. With growing technological advancements and improvements, there is a vast array of technology that identifies infringers. PicScout is an example of one of these platforms, and we will go through that in a little bit more detail a little later on. So just keep in mind that it's not only the creators that are looking out for infringements of their rights, technological advancements also help to do this too. Bad PR is also another reason why we should be worrying about copyright infringement. If you do infringe a creator's copyright, bad PR may follow. Social media is a growing forum where creators whose rights have been infringed may vent their frustration about a particular company or individual who has committed a copyright infringement. Often, the bigger the company, the bigger the story, which may also be picked up by newspapers and other media. There are a number of misconceptions surrounding copyright, and we will go through some of these myths so that we can be adequately informed when making decisions about using works that are subject to copyright. It may be surprising, but all points on this slide are copyright myths. Copyright laws generally apply to materials on the internet in the same way that applies to other platforms. Many websites have specific copyright statements that relate to the content that appears on their site, that tells you what you can and cannot do with the content that appears. If content is on the internet, it doesn't necessarily mean that it's in the public domain, and therefore permission must still be sought. Likewise, just because there is no copyright statement or watermark doesn't necessarily mean that you have the right to copy that material. I often hear individuals say, if I don't profit from the use, I don't need permission. This is incorrect. If anyone wants to enjoy any of those exclusive rights of the creator, permission must be obtained, regardless of whether or not profit is made from that use. When it comes to social media, it is really important to make sure that you abide by the terms and conditions of that social media platform. Generally speaking, most social media networks allow users to enjoy the inherent tools of that platform. For example, share a post or retweet a tweet. However, this does not mean that you can copy and paste or extract that video and use it for your own purposes outside those inherent embedded tools of that social media platform. If I alter an image, I don't need permission to use it. Once again, this is incorrect. If you're planning to use an adaptation of a work by changing the image from black and white from color or creating an artistic illustration, you still need permission from that original copyright creator. Another common misconception is that royalty-free images means that you can use an image for free. Royalty-free is a licensing model that generally means you can pay a one-off fee and you'll have very broad, worldwide perpetual rights to use that image without paying a fee for every single use. But a license is still required. The last example on this slide is important to show where responsibility lies. If you are the URL or domain name owner, you are the one that is responsible to ensure that any images appearing on your website have been correctly licensed. It is a good idea to ensure that your web designer, who may have licensed the images on your behalf, lists you or your company as the end user of the images to avoid any confusion about who holds the rights to display the images on that website. If you are a web designer, although the liability does not rest with you, it is ideal to ensure that your clients have the appropriate license in place, particularly from a relationship management point of view. If you are not sure who is the creator of an image, there are many free online tools and apps, such as PicScout or reverse image search, that will help you find whether an image is available to license and where and how you can secure relevant permissions. One of the most common problems that we come across is that of small businesses failing to seek assurances from creative agencies or third-party designers that a valid license has been secured. So make sure that when permissions have been sought, you keep copies of those licenses and calendarize or track any expiration dates. We often hear business owners say that they were not aware that they were required to renew their license or replace the image once it has expired. So make sure that we're keeping track of the rights that are granted to us. It is also very important to know the terms and conditions of your license, as there are many different types of license models, such as royalty-free, with that traditional broad grant of rights, to rights-managed models, where the grant of rights is very specific. Many licenses often have very specific restrictions that we need to take note of as well, such as no use in a logo, or no pornographic or defamatory use. So make sure that you have read the relevant T&Cs and ask questions if you are unsure of the meaning of a certain term or how this affects you. One of the best tips I can give when wanting to use content is if you don't know where an image originated from or who owns its copyright, it is best to seek an alternative image so that you can contact the copyright owner to obtain permission to avoid committing a copyright infringement. Lastly, it is important to think about other intellectual property rights that may exist in an image, or whether or not you need permission from property owners or people appearing in images for your use. We'll go into this in a little bit more detail in later slides. This slide shows an example of how you can find a copyright owner. The launch tool on the PicScout website is quick, easy, and a free way to identify creators and where you can license that content from. One of the benefits is that you do not need to download any software or save the program on a desktop. Given this is a web-based tool, you can access the URL at any time. All you need to do is click on the launch tool, upload the image that you want to know more about, and the tool will populate the results for you. When you are securing a license for your use, it is very important to make sure that the licensing model and the associated terms and conditions fully encapsulate your planned use. For example, if you plan to use an image on your brand's social media network, you must ensure that your license allows these rights. There are also other licensing models, such as embed or Creative Commons licenses, that allow permission for use on content. Likewise, it is very important to read those terms and conditions of those licenses, as many of these free licensing models allow for personal editorial use only, such as a blog, and require an attribution or credit line afforded to the copyright owner. In addition, many of these free licensing models do not provide any warranties or indemnities. So depending on your needs, you may need to look to alternative image sources that do provide relevant warranties and indemnities. Many free image libraries or platforms and some licensing models do not allow for commercial uses. Therefore, if you plan to use content to promote a product, service or brand, or in native advertising, or in any use where there is a suggestion of endorsement or sponsorship, you will need to ensure that your license provides for these specific rights. Otherwise, your use may be a copyright infringement. So make sure your proposed use is covered by those license terms. Often, content that is subject to copyright contains other elements that are also subject to copyright or other intellectual property laws. If you are using content for commercial purposes, you may need to think about obtaining additional releases. Let's take the image on the slide as an example. If this image were to be used for a commercial purpose, so that is to promote a brand, product or service, or in content marketing or native advertising, you would need to think about a few things. You would need to think about whether or not you need to obtain permission from any people that may be recognizable within the image. And of course, this is aside from the permission that you would have already obtained from the photographer of the image, given the copyright considerations that we've previously addressed. You may also need to think about whether or not you need any permission for any artists of the artworks that appear within the image. Or also, you might need to think about whether or not you need any permission from the art gallery, particularly if an admission fee is paid to enter the gallery. If using content for commercial purposes, keep in mind that your use may need a release or permission from recognizable people, building owners, trademark owners, animal owners, if that animal is used for profit, and also artwork creators. You should be asking yourself questions like, is my use commercial? Meaning I would need to think about obtaining these additional permissions. Or is my use editorial, or is it for newsworthy purposes, where I really don't need to think about seeking these permissions? But if my use is commercial, then I need to be asking, can people be identified in the image? Do I need permission from any building owners? if there is a focus on any particular building, or are there any logos or trademarks that are visible within the image, or if there are multiple logos, as is pictured on this slide, then perhaps I do not need to secure permission. But if I were to crop the image and create a focus on one or two of these trademarks, then perhaps I do need to think about obtaining permission. It is not just celebrities that are recognizable. Each image on this slide contains a person or people that are recognizable. There are many things that may make someone recognizable, and you should think about whether or not your use is commercial and whether or not you would need to seek a release or permission from the people appearing in that image. Features that may make a person identifiable include hairstyles, as can be seen on the middle image, any unique scars or birthmarks or other unique features, their surroundings or costumes or uniforms, as you can see in the far right picture. Any crowds or groups of people may make somebody identifiable. And also tattoos. Tattoos can also make somebody identifiable, even if you cannot see the face of the person who has that tattoo. Additionally, a tattoo itself may also be subject to copyright of that tattoo artist. After all, that is an artistic creation. You probably wouldn't need to be so cautious for common tattoos like an anchor on an arm, but most definitely should be sensitive to tribal tattoos and other unique or detailed tattoos. If you plan to use buildings, private homes, businesses displaying trademarks, and landmarks for commercial uses, you would also need to think about obtaining permission. One way to reduce the risk is to use an image of a skyline or a cityscape, where there is no particular focus on any one building. But it's important to keep in mind that cropping an image or using an image that focuses on a particular building or landmark will increase the risk of a claim. If an image contains an animal that is used for profit, for example, animals in a circus or within a zoo, you would also need to think about obtaining a release from the animal owner if your planned use has a commercial purpose. For artworks, you also need to watch out for artworks like paintings, sculptures, drawings, and maps. If images containing these types of works are used for commercial purposes, you may need to think about obtaining releases from any artists or sculptors. If the artwork is a creation of a celebrity image, such as the Bruce Lee statue in Hong Kong in the far left image, you may also need to think about obtaining permission from the Bruce Lee estate for using his likeness within your commercial campaign. One of the most useful and practical tips I can give when licensing an image from a photo library is to make sure that you check the release information on the asset detail page. This will tell you if the image does or does not come with a release. If the image does not have a release and your use is commercial, you should think about whether or not your use is commercial and whether or not you should think about obtaining additional releases. Something to keep in mind is that editorial images most always come with no release. So you should keep in mind that there is no release from any celebrities that might appear. It's the creative images, such as royalty-free and rights-managed images, that can cause a little bit more confusion, because many of these images are released and also many of these images are not released. This checklist will help you safeguard against potential legal action. You need to ask yourself, do I have permission from the copyright owner? Have I kept a copy of the license that governs my use? Have I thought about releases for my use if necessary, if my use is commercial? And have I thought about how I get these releases? Do I have a relationship with the talent or property that might appear within the image? For example, you might be a sponsor, or your company might be a sponsor of a particular athlete. And in those circumstances, you will have a relationship with the talent or the sports person that might appear. Alternatively, many photo agencies, including Getty Images, can assist in obtaining clearance or permission. There's also many resources available for you. You can refer to your local intellectual property offices. You can also look to content providers such as Getty Images, who have free publications such as newsletters, FAQs about copyright, and also online free tools such as PicScout and the PicScout app, reverse image search, and TinEye. This is just an example of Getty Images' free publication that is available to the public to help create a culture of awareness about the importance of copyright and respecting the rights of creators. It is available if you search Getty Images stories and trends. That's it for the content of the webinar, but I can see that there have been a number of questions that have come through, so I'll read some of those out in case they weren't broadcast to all, and we can go through those. So Keith Van S asks, if I buy a photo for certain projects, can I use it for another project and another client? This is a really great question, and something to keep in mind is that only the licensee has the right. So if you purchase an image as a purchaser on behalf of your end customer client, who is the licensee, only that customer and licensee has the right. You can't then go and use that same image for other customers because it's only one licensee per license. But of course, if you have other customers that would like to use the same image, you can secure a license on behalf of that customer also. Okay, I have another question from Samantha Go, who asks, which party is held responsible for keeping track of your rights? Is it the agency or is it the client? Ultimately, wherever that content appears, whoever owns that platform, they are the ones that are responsible. So if it's on a website, it is the URL or domain owner. Or if it's a printed publication, whoever owns that publication, they are the one who is responsible to make sure that they have a valid license for that use. But from an agency perspective, when you're creating works on behalf of your customers, from that customer relationship point of view, it is great to be able to go to your customer and reproduce the terms and conditions and a copy of the license so that they can keep track of their use rights. There's also a question from Bennett Leon, who asks, can you define the difference between commercial and editorial use? That's a really great question, and sometimes the area can be quite grey, for example, native advertising. Essentially, an editorial use is anything that is a newsworthy or public interest purpose. Anything outside of that is a commercial use. Of course, the scale of commercial use can be quite different. So like I mentioned, native advertising, the look and feel of the article can be quite editorial, but the ultimate purpose of that article is to promote a third-party brand. There's red flags such as presented by, sponsored by, brought to you by. If that article is paid for by a third party, that will be a native advertising and will be commercial. And of course, on the higher end of that spectrum, you have clear-cut billboard commercial campaigns. So I hope that helps to clarify a little bit more the difference between commercial and editorial use. Okay, I have another question from Daphne that says, can I know if we shared our friends' photos on Facebook, does that mean we're infringing the copyright? So with social media platforms, if you're using the inherent embedded tools within that platform, such as like or tweet or repost, then that is actually okay, because the terms and conditions of that social media platform generally say that when a user uploads content, you're allowing people to use those inherent tools, such as like, retweet, or share. But that wouldn't allow you the right to screenshot that image or copy and paste that image and place it elsewhere on your own platform. I see a question from Tim that says, are we able to get a soft copy of this presentation afterwards? Yes, Tim, there are going to be some collateral that is available after this presentation, and a copy of this webinar will also be online. Okay, a question from Dina. Should I retouch an RF image for use in my visual for a commercial client? For example, take the head of an image B to replace face of image C. is this considered infringement? So it is really going to depend on what the terms of your license allow for. With most royalty-free licensing models, you are permitted rights to edit and modify that image. But just keep in mind that if you do modify or edit an image and a claim comes about because of that modification, you're going to be responsible for that claim. Something else to keep in mind with royalty-free images is that some of those images are released. So if one of those images is released, you wouldn't need to think about getting a release from any people that appear in the image. So I don't know if that helps you on whether or not you want to modify that image to replace their head. Okay, I just have to scroll up. There's a few more. Okay, there's another question from Michelle that says, what constitutes a commercial use? Does this mean that as long as a commercial entity is using it, it is deemed commercial regardless of the content format? So that's actually a really great question. You need to ask yourself, what is the purpose of the work or collateral? Is the purpose to create awareness about the brand or the company? In which case, yes, that use is going to be commercial. I've got a few more questions coming through. Another one from Dina. With RF images, if I have purchased it for a client with a global footprint, are the clients allowed to share the images with the vendor in the network and use it for the brand's ad? That's a really great question. Just keep in mind that only one entity has the rights to use the image, and they can use that image on that global footprint, but only that entity has rights. So for example, if I worked for Getty Images South Australia, I could produce a work and I could distribute that to our global footprint. But that doesn't necessarily mean that I could give that image to somebody from Getty Images South Singapore, because that is a separate entity. Another question from Tim. How do artists typically pursue or seek recourse for copyright infringement if they notice their work in commercials? So it really is up to the copyright owner on how they want to address this. Most copyright owners or their representatives will generally reach out to somebody who's infringed their copyright and request a settlement for the use of their image without a valid license to do so. Okay, another question from Tracy. How does copyright work on personal blogs? Is it okay if we credit the copyright, or do we still need advance permission? We still definitely need to have advanced permission. Even if we're using content or articles in a way that is a personal use or an editorial use, we still need to have permission from the original creator of that work. Just simply crediting where you got an image or an article from is not enough. You need to have permission, prior permission. Okay, another question from Chris. If the image is used for a brand guideline as an image guide, not for commercial reproduction, is there a copyright issue? So Chris, it's important to keep in mind that if we want to use any of those exclusive rights of that copyright owner, there is a copyright issue. So if we want to reproduce a work, even if it's just for a use within an internal presentation, we still need to make sure that we have a valid license to do so. If that use has a low exposure, such as just brand guidelines that will be internal, then the license fee might not be as large as a license fee, for example, on a billboard, but we still need to make sure that we have secured relevant permission. Okay, another question. Okay, if we purchase an image from Getty Images and are unsure about the rights or how much we can edit or manipulate the images, are we able to check with your consultant? Of course, we would love for you to contact your local Getty Images representative, and then they can help you understand the rights that have been granted to you. And if you want to know whether or not you have rights to edit or manipulate content, you can definitely reach out to them to ask. As a general rule for Getty Images content, you do have the right to edit and manipulate royalty-free and rights-managed content, but editorial content should not be manipulated. Okay, another question from Ian. How much is the liability if it's breached? That's really a question for the courts to decide. So unfortunately, I can't give you too much guidance on that. But generally speaking, if you want to know how much a license fee would cost, you can always have a look at the pricing calculators online to determine how much the general fee for that use would cost. But keep in mind, if there is a breach of copyright, the fees may be different. I think that's most of the questions. Oh, a question from Juliana. How does our own images should be protected? So as soon as a work is created, copyright is automatically afforded. You're not required to include a copyright notice or a watermark to show that that is your image. Okay, a question from Cynthia. If I download free pictures, can I use them for commercial use, such as creating a light box? You really need to refer to the terms and conditions of where you downloaded that free image. If you downloaded a free image via an embed tool or via a Creative Commons license, there's all different licensing models that relate to the different images that are available. Some of those terms and conditions might say no commercial use at all. So you really need to make sure that you're keeping track of the terms and conditions associated with the image that you've downloaded. So I think that has addressed most of the questions that have come through. But if you do have any additional questions, feel free to reach out to your local Getty Images representative, or alternatively, you can contact the email alias that will be sent out in the collaterals that are following this session. So thank you very much for your time. That's it on copyright.